So the Supreme Court has relisted the challenges which aim to strike down assault weapon and magazine bans nationwide. So let's break down what is happening and what this might signal. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is First Form. You guys know that First Form's an American-based company. They have amazing supplements, protein powder, energy drinks, pre-workout, all of those things that you need to get healthier, but they're pro-freedom, pro-America, and they support the Second Amendment. So if you're interested, check them out using the links down below. And if you use my link and you order something $50 or more, you'll get a free 4-pack of energy drinks. As I mentioned in the intro, in this video, we're going to be talking about some very important developments in a couple cases which are challenging various state bans on so-called assault weapons and then magazine restrictions as well. These critical cases are Snope versus Brown and then also Ocean State Tactical. We've been keeping our eyes on these two cases for a long time because the Supreme Court has relisted them now multiple times. They sent them to conference multiple times and then relisted them after, and we were all hoping that they would grant review to at least one of them, but they continue to be relisted. However, not all hope is lost because these cases, once again, have been relisted for conference this Friday, March 21st. So we need to talk about also what this signals and how the number of relists that now these two cases have reached could signal something that's actually potentially positive. Now, for those not aware, the Snope case is kind of the biggest case out of the two because it deals with a state's ban on so-called assault weapons, and it was prior GVR, meaning that it was granted, vacated, and remanded by the Supreme Court after they issued their 6-3 ruling in Bruin. This case involves the state of Maryland defining certain firearms as so-called assault weapons and therefore banning them within the entire state. This ban was challenged in a federal district court in Maryland. However, that court dismissed the case because of some prior precedent that was on the books out of the Fourth Circuit that had already upheld the Maryland ban as constitutional. This case, Snope conceded that precedent, that case Colby, was a controlling case, but they stated that it was incorrect and should be reversed. Now, after that district court dismissed the case, it was then appealed to the Fourth Circuit. And once again, the Fourth Circuit upheld that dismissal, saying that we have precedent in this area. We can't review this. It's locked in. And so at that time, this Snope case then went to the Supreme Court, and that was back in 2022. The Supreme Court ultimately ruled in the landmark Second Amendment case Bruin, and then after that, this case Snope, which was prior Bianchi, this was then GVR'd, meaning that it was granted, vacated, and remanded back to the Fourth Circuit for a new decision in light of what the Supreme Court said in Bruin. Now, this case was opened back up in the Fourth Circuit, and the court held oral arguments before a 3-judge panel. But the case essentially sat for 13 months, and then we received essentially an order from the Fourth Circuit en banc panel saying that they were going to take this case back, that they didn't want the 3-judge panel to rule in this case, and so they took control of it. Eventually, the Fourth Circuit en banc panel did issue their decision, and they upheld the Maryland rifle ban once again. In that decision, the Fourth Circuit upheld the state's ban using the incorrect military use test. Essentially, the Fourth Circuit believed that AR-15s are useful in military service and therefore they could be outright banned by state. As a result of that horrible decision and analysis, this case is once again back in front of the Supreme Court seeking a reversal of what the Fourth Circuit said. This Snope case was originally set to go to Supreme Court conference back last December, but then the court preemptively decided to reschedule this case. Now again, a reschedule is a little bit different from a relist, but the first action they took on this challenge was a reschedule. It was then set for conference for the first time after that reschedule for January 10th, and then since then, we have now seen this case, along with another one, Ocean State Tactical, get relisted multiple times. The most recent conference that has now been set in this case is for March 21st. Now, the other case is Ocean State Tactical, and in that case, the plaintiffs challenged the state's magazine ban and the lower court's denial of a preliminary injunction. The Ocean State Tactical case has now also been relisted for the next conference. It has been set along with the Snope case, and every step along the way now Ocean State Tactical has trailed with Snope, which also is very interesting. Now, you may be asking yourself, what is going on with all the relists? Is this a signal of a good thing, a bad thing? Why is the Supreme Court relisting these cases so many times, and what does that signal? Well, really, relists are very important. It can tell you a lot about the mindset of the Supreme Court. A lot of the analytics and data and tracking in the Supreme Court shows that a case has a higher odds of actually being granted review if the Supreme Court relists it at least one time. There's a lot of data from the 2016 to 2020 terms that shows around 31% to 43% of all petitions that were relisted at least one time were eventually granted review by the Supreme Court. So the data shows that you want your case, your petition to be relisted at least one time, maybe twice, to essentially get Supreme Court review, and you have higher odds. But there's also a lot of data that shows the more times that your case is relisted, like kind of what is happening with Snope and Ocean State Tactical, that could be typically bad. There's a lot of data that shows that, if your case is relisted 3 times, 4 times, potentially 5 times, the likelihood is that the Supreme Court is going to deny review to your case. And what potentially is going on is there is a dissent being written in that case, and that's typically what happens in those situations. But there is still hope in a lot of these cases because that is not always 100% the truth. There are a lot of high-profile cases that we treat differently when there are multiple relists. For example, in the Dobbs abortion case, that was relisted 12 times before it got the official notice on the docket that the Supreme Court had granted review. Also, now we know that there's been multiple, kind of leaks and reports about that whole scenario where the Supreme Court had actually already decided to grant review to the case, but they just kept relisting it, pushing it off on the docket until eventually it was pushing out into the next term, and then they made the official notice on the docket that they had taken the case. So the relists almost serve as a placeholder until they put out the official notice that they had taken that case. Also, there are other high-profile cases like the Masterpiece Cake Shop case, which was relisted 14 times before it was officially granted review by the Supreme Court and was put on the docket there by the Supreme Court. A high number of relists can begin to indicate 2 things beyond just a denial and a dissent. It could mean that the justices actually voted to grant the petition and resolve the case summarily, so the petition gets relisted until the unsigned majority opinion is ready to be filed. So that is a, potentially very good situation where maybe something like a per curiam opinion is coming, an official opinion by the Supreme Court at large, not signed by anybody specifically, and they just use the relist as a placeholder until they issue that opinion by the Supreme Court. Now, the other option, like I mentioned, is when the justices have already voted to grant the petition, but they're just using those multiple relists as a placeholder until they make the official public statement on the docket. So where does the data and developments in these cases actually leave us in these specific cases? Well, the first domino in my mind kind of fell when the Gray versus Jennings case was denied review by the Supreme Court after the January 10th conference. However, since the Supreme Court did not outright deny review in the similar Snope case, in the Ocean State Tactical case, that could be a potential good sign. And now at this point, these cases have been relisted about 7 times, 8 times if you count the distribution that was set prior to the reschedule. So 7 or 8 times now, these cases have been relisted. So what does that high number of relists indicate about what's happening in these cases? If you want to draw a positive conclusion from what's going on in these cases and the 7 or 8 relists, you could say that there is potentially a higher interest in the Snope and Ocean State Tactical case because they are higher profile. One of them is a final merits case. It was GVR'd prior by the Supreme Court. The Supreme Court is very familiar with the Snope case because they've reviewed it prior. And again, it deals with potentially striking down rifle bans and magazine bans nationwide. Very high profile, a landmark Second Amendment case if they took it and ruled on it. So the multiple relists could indicate a very high interest in these challenges. Again, that's kind of looking at it in the best light. There's always an outside chance that the multiple relists could simply be a product, like I said, of heightened interest, or it could be a product of them simply writing a dissent in a denial could be coming. But also keep in mind when you look at other Second Amendment high-profile cases like New York State Rifle and Pistol Association versus Bruin, that was relisted 4 times before it was granted review. So as these cases climb with more and more relists, now we're at 7 or 8 relists, that is the indication, if you wanted to take it in the best light, that there is a heightened interest in these cases, that the Supreme Court is actually interested in this. Maybe it's beyond something than a simple denial and a dissent. Maybe they've already granted review to it, and they're just using the relist as a placeholder, or maybe they've decided to actually write something like a summary opinion, a per curiam opinion, and they're just using the relist once again as a placeholder until they issue that opinion. So these cases are now entering a very critical stage. All eyes will once again be on the Supreme Court, kind of like Groundhog's Day, watching the Supreme Court after the conference, watching the order list the following Monday, hoping that we get some positive news from the Supreme Court. So that's what's currently happening in the critical assault weapon and magazine ban cases. And that's where, my head currently is at when we're seeing these 7 or 8 relists. So as we get more information, I will let you guys know. If you like this video and you'd like to support the channel, One of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.